So welcome everyone. I'm Lauren Guy. I'm from Edward Cooke Family Law. I'm a director there and I head up our modern family team.
My name is Richard Jones. I'm a family law barrister at One Garden Court Family Law Chambers, and I specialise in all aspects relating to child law, in particular child protection and law relating to surrogacy.
So I think we're all on mute to start with. If people have questions, comments, discussion points they want to raise, please do take yourself on mute. But if we can leave it on mute when we're not talking, it just avoids all that horrible feedback that nobody likes dealing with. So today we've been billed as a modern family seminar for family lawyers who don't usually do modern family work. So what did we mean by that? Clearly modern family work's an important and a developing area in family law. But as a committee, we recognised that another surrogacy for beginners seminar or something along those lines, realistically is probably going to have limited practical use for most of our members. It's unlikely you're all suddenly going to go off and create your own specialist surrogacy practices. So instead, we decided to concentrate on the intersection between modern family law and our bread and butter separation and divorce work. So our aim today is that you walk away feeling a little bit more confident dealing with a modern family issue if it crops up in your day-to-day work. So we've worked our slides around two very simple case studies, each looking at a separating couple who took a non-traditional route to create their family. Richard is going to help us understand the first case study.
Thanks, Lauren.
So, great. So we're meeting with Barry at the office. Barry's married to Sue, but they've recently separated. And Barry and Sue have one child who is Gemma, who's 9 years old. And Gemma was born as a result of the surrogacy arrangement in the US. So Richard, what's the first thing that we need to think about in this situation?
So first of all, when this couple come in, or someone comes in, Barry in this case, you need to think about who has what in terms of parental responsibility and who is the parent effectively here. Can I just pause before I go on to this and say a couple of things about this area of law? As I know most of you will be aware, this is very much an area of law that is in flux. There was a Law Commission report earlier this year recommending, for example, that the process of obtaining parental orders become streamlined. That hasn't happened yet, but that is a recommendation. So as this translates to you in your practice day to day, is that this is quite a messy area of law at present. It will be streamlined, but at present it is quite messy. So just for you to be aware that when you're meeting Barry at your office, this is very much an area that is present in flux. So the first thing you need to know is in relation to the child, has a parental order been made in relation to Gemma? Now, just to be clear, parental order is an order which ends the surrogate's parenthood, so that it is literally a transformative order, whichever country it's made in. It is a transformative order that makes the applicants the parents of that child and terminates the parental responsibility of the surrogate. So when you meet Barry, and you need first of all to establish, has there been a parental order made, and of course in whose favour it has been made. If one has been made, then as I say, they are very much the legal parents under the UK law, and they will have parental responsibility for Gemma. So what does that translate as? That translates as that you can effectively work on the basis they both have PR. There's nothing to worry about in terms of the fact that Gemma was born as a result of a surrogacy arrangement.
Richard, if that comes into our offices and they've got the parental order in place, but they're now separating, we just deal with it as we would any other child arrangements case?
Absolutely, it's the welfare principle. So that is fine.
What if there is no parental order?
So if the answer is no, then the first protocol, quite bluntly, is that you need to sort out who's who, because just to be clear, in terms of parental responsibility, if Gemma was born as a result of a surrogacy arrangement pursuant to the HFEA 2008, the surrogate who gave birth to Gemma will be the mother and will be regarded as a matter of law as the mother. And as has been put here, this is the case even if Sue and Barry are on the birth certificate considered to be legal parents in, for example, America, if it takes place in America. So Sue would not be the mother if there is no parental order. And if the surrogate was married to a man or a woman, and that man or woman consented to the transfer of an embryo or eggs and sperm to the surrogate, then neither Sue or Barry would have parental responsibility or be deemed as the parent. So it is really important that you establish at first go if there is a parental order. Now, there's a whole host of reasons as to why people do not apply for a parental order. And can I just say, first off, the most important message to give is to tell them not to panic, because as we'll see in a moment, the courts have been very accommodating in a messy situation as to making parental orders where possible. It's late or comes in unusual circumstances. So why don't people apply for parental orders? Well, first of all, they just might not be aware of it. They may think, well, we got orders in America, we got orders in Ukraine, for example, and surely it's all fine. No, you do need a parental order in this country to reflect your status as a parent. So some people simply aren't aware of that. So that's the first reason. And of course, when they receive legal advice in a other jurisdiction, and they think, well, we've got our orders from the court in California or wherever, then we don't need to do anything when we come back. Bottom line is, yes, you do. So they may say, well, we got these orders wherever. It does not matter. They do need to apply for a parental order here.
And that's the case no matter how long they lived in that other country or whether they're from that other country, we just wouldn't recognise that parental order or their equivalent.
Not a bean, quite frankly. They need to apply in this jurisdiction.
So who are Gemma's legal parents if there is no parental order?
So, as I was saying a moment ago, surrogate who gives birth to the child is the legal mother. We are well used to, in the cases we deal with, under Section 2 to 4 of the Children Act 2 of 1989, that, of course, a mother will have parental responsibility automatically unless it is removed by adoption or by a parental order. So it's important to remember that a surrogate who gives birth to the child will be the legal mother. That may change in the future, given what the Law Commission says, but for now, that is how it remains in English law. If the surrogate is married or in a civil partnership, then if they consent to the embryo or eggs and sperm being transferred, then they will be deemed as the other parent. If the surrogate is not married and the intended father is not the child's biological father, then the intended father will be the father. So it is quite complicated. So just to be absolutely clear, if married or in a civil partnership and that partner then consents to the transfer, then they will be deemed as the other parent. If the surrogate is not married and the intended father, is the child's biological father, and the intended father, it will be the father. So it's really important to get that absolutely right. So sorry, and was the surrogate married, and where was the surrogate married, and whose gametes were used to create the embryo? So this is important we get this right. If the surrogate is unmarried and there is a genetic link, Barry is Gemma's legal father. So there's no partner to consent. However, Sue will not be Gemma's legal mother, and it will almost certainly be Gemma's best interest to remedy this by way of applying for a parental order for the avoidance of doubt. So just to be clear in terms of surrogacy, the genetic link is really important. That is effectively what creates the situation for surrogacy. In terms of the embryo, there does need to be a genetic link with one of the applicants, with either the applying mother or father. The surrogate married or no genetic link, Barry is not Gemma's legal father. So if the surrogate is married and the husband, for example, consented to the transfer, he will be deemed as the father, not Barry. And again, if there is no genetic link, then again, Barry is not the legal father. So you can almost do it in a checklist type way to see whether Barry is the legal father or whether Sue is the legal mother. But in terms of the application of parental order, whether there's a genetic link and whether the surrogate was married or in a civil partnership are some of the key features that you need to be aware of.
So Richard, to apply for parental order, there always must be a genetic link, but the key here when we're looking at parenthood, if there's no parental order, this key is whether Barry's got that genetic link to Gemma if the surrogate's unmarried.
Absolutely, absolutely. The genetic link is key.
So can Sue and Barry apply for a parental order at this stage? So we've got on the screen, Richard, the fact is that section 54 of the HFEA 2008, that's the Human Fertilisation Embryology Act 2008. And I'll hand over to you.
So thank you, Lauren. So in circumstances where an application comes before the court will have to go through the checklist at section 54 and be clear that the decision to make a parental order is in the child's best welfare interests. So what will the court look at? Well, the court will look at the criteria in section 54. Was Gemma carried by a woman who was not one of the applicants as a result of placing her of an embryo or sperm and eggs or artificial insemination? Answer, yes. Is there a biological link? The gametes of at least one of the applicants was used, that of Barry or Sue? Answer, yes. The applicants are living together in an enduring relationship. I pause there because, as I said earlier, the courts are very keen, where possible, to what termed read down legislation, which means try and be accommodating, in short, to applications for parental orders where they don't strictly meet the criteria where possible. So in an order made after parents had separated, and it was found that the parents had an enduring family relationship in respect of their commitment to the child. So the definition of an enduring relationship was seen in rather broad terms. Same thing, and this was a seminal case, was re X, because the application for a parental order is to be made within 6 months of birth. However, re X, where it came much later, the court again interpreted broadly the timescales and did in fact permit the application out of time. Gemma's home would have to be with the applicants, and either or both of them must be domiciled in the UK. I should pause there again. So there's quite a lot of case law in relation to domicile. I do not think you need to get too hung up about it. The bottom line is, where is their home? Where do they call home? And of course, the applicants must be over the age of 18. Key, and I know there's been a recent decision in fact, which Edward Cooke's solicitors have been involved in before Mrs. Justice Gwyneth Knowles, there must be consent. It cannot be given within the first weeks before birth, or the order can be made without consent if the surrogate or spouse cannot be found. But you do need to get consent. That is extremely important. And there should be no. I'm so sorry, Lauren.
I was going to say, in that case, if you can't find the surrogate, you are expected to really do everything you can to find them. Although there were some cultural restrictions in that case, and the court was very alive to the fact that they didn't want to place the surrogate or her husband, if she had one, at risk because of all how surrogacy might be viewed in her community.
Absolutely, and I think the key word in that case, as I recall, was proportionality. You
Absolutely.
have to do all you can and be proportionate about it. And key is that no money or benefit other than reasonable expenses should be paid unless authorized by the court. I have yet to see a case where a parental order has been declined on the basis that the sums of money exchanged were not deemed reasonable expenses, but it is something you need to tick off. So in summary, therefore, in terms of what to look for when Barry comes through your door or Sue comes through your door, is to be clear whether there is a parental order. If there's a parental order, that in effect is fine, can be treated in terms of who spends time with, like any other case, of course, welfare applies. If there is no parental order, then you need to delve a little further into the nature of the arrangement, for example, consent, whether the surrogate was married, and therefore, consequently, who is the parent. And that is extremely important to get that right at the beginning. So I think that clarifies, if I may say so, the situation if Barry comes through your door. If Barry and Sue do not have a parental order, of course, they do need to go to a specialist because there are many trip faults, if I may say so, both in terms of the Section 54 criteria and more broadly in relation to surrogacy, to make sure that that is avoided. But as we have here, if there are parallel child arrangement proceedings, then permission of the court may be required to make a Section 8 order if the applicant is not a legal parent. So I make this plain that, of course, whilst there are many problems identified here, they're not by and large insurmountable in terms of coming before the court. Because even if you need to make an application for permission to make a Section 8 order, that of course can be done. But just to get on your checklist, is there a parental order? Who is the parent? And for that, do go to HFEA 2008, Section 35.
And I think don't forget about Section 8, because actually, if there isn't a parental order and there's not that biological link with Barry, one thing to be aware of is it might be that neither Sue nor Barry are the legal parents nor have parental responsibility. So you may need the court to look at the issue of parental responsibility quite quickly. Who's making legal decisions for Gemma while she's in this limbo.
Absolutely, and a lot of people are unaware that if they don't have a parental order, for example, case scenarios, they aren't legal parents, they don't have parental responsibility. That is a situation that can be remedied. It can be remedied swiftly by applying for parental responsibility or a lives with order. It can be remedied. So, if I may say so, the key thing to tell Barry in those circumstances is not to panic. It is a situation that can be remedied even in the interim before a parental order is made.
Absolutely. And in fact, you could have those proceedings running parallel, couldn't you?
Absolutely.
If there was a dispute, child arrangements dispute, you could have that going alongside getting the application for the parental order started, I would imagine.
Absolutely. But the key thing is just to get Gemma covered in terms of someone having PR in this country, exercising day to day. So you just need to get the interim sorted, and of course you can worry about the long term as proceedings unfold.
Perfect. So that brings us to the end of our surrogacy case study. Has anybody got any questions for Richard before we move on? No, let's move on swiftly then. Oh, I just moved on too far, excuse me. So in this case study, we're meeting with Claire. She's been in a relationship with Tracy. They're not married here, but they've recently separated. They have one child together who is Freddie. He's 2 years old, and he was born as a result of donor conception. So that's using a sperm donor. So there's a little caveat here, because I'm only dealing with the law from the 6th of April 2009. That's because the law was very different pre the HFEA 2008. And if I try and deal with both scenarios, it's going to get incredibly confusing. So if you are dealing with much older teenagers, we're looking at really 15 plus. So I don't think those cases are really crossing our doors all too often. But if they are, you need to be aware that this wouldn't be the right procedure in that situation.
It's fair to say there'd be a very rare beast, wouldn't it, Laura?
It would. So as you can imagine, if I was dealing with both, this flowchart, which is already, I think, busy enough, would be incredibly confusing. So before we really get into talking about Claire, Tracy and Freddie, this area, I mean, surrogacy is complicated. Legal parenthood in this area is just as complicated. So I've put together a flowchart which is going to help us identify who the legal parent is in the family that we're dealing with. So I'm going to start at the top. Was conception as a result of intercourse? That's the first question you have to ask. We have to ask awkward questions in our job, and this area of law is certainly, an area where we have to get used to and comfortable with this. So if the conception is as a result of intercourse, then the biological father will always be the legal father. You might think that is obvious. That said, I have on numerous occasions dealt with situations where the parties involved consider it to be a donor conception arrangement. And when you just scratch below the surface, they tell you, oh, but we decided it would be nice to have a natural conception, meaning intercourse, meaning this isn't a donor conception at all. The biological mother is the legal mother, the biological father is the legal father.
So it's as simple as it looks.
Absolutely, despite the fact that people may view their situation in a different way. So it's not a result of intercourse. So the first thing we need to ask is, did conception take place in a licensed clinic? We're talking about a licensed clinic in the UK here, because the HFEA 2008 wouldn't apply outside of the UK. If the answer is yes, then did the couple present at the clinic together, and were all the consent forms properly completed? We are going to assume that the clinic knows what they're doing. There have been situations where clinics have been audited, and it turns out that there's been discrepancies with paperwork, which, as you can imagine, has caused all sorts of difficulties with legal parenthood. That is beyond the remit of our seminar today. It is going to blow all of our minds if we try and go down that rabbit hole. But it is an area of law that if it ever came up on your cases, it's pretty unusual that Richard or I would be very happy to help with. So did they present together? All the forms are properly completed, yes. Then the mother's spouse or partner is the second legal parent. If they didn't present together and the partner hasn't completed all the forms for consent along with the birth mother, then the child has only one legal parent, which will be the birth mother. Then we have cases where conception didn't take place in a licensed clinic. We're seeing artificial insemination at home happening more and more often in this area of law. The key question here is, was the mother married or in a civil partnership at the time of conception? If she wasn't and she has a partner but they're unmarried, not in a civil partnership, then the mother's partner is not going to be the legal parent. In this situation, if the mother is unmarried, whether they're single or in a relationship, the biological father is going to be the legal father, regardless of whether the intention is that it's a donor setup. And we'll come to that again later in a bit more detail. If the mother was married, then we need to check whether the mother's spouse or civil partner consented to the treatment, to the insemination. If they did, then mother's spouse, civil partner is going to be the legal parent of that child. If not, then we're back to the biological father being the legal parent.
Sorry, Lawrence, there's two things there then. So one is, are they married or in a civil partnership? And secondly,
They must consent.
consent.
Absolutely. We need both of those factors. So there's no presumption of legitimacy.
Sorry.
Sorry, we're talking over each other. So when we're dealing with same-sex couples and the HFEA, there's no presumption of legitimacy just because you're married. So that's quite a big distinction.
Thanks.
So in theory, we should be able to rely on the birth certificate to tell us who the legal parents are. That said, things are not always that simple, and it's always worth checking the position around conception because we don't want any nasty surprises later on down the line. Registrars are not infallible. This is a really complicated area of law and mistakes are made. Just to put that in context, I've got two examples from my own work. I had one case where a lovely same-sex female couple came to see me. Partner A was pregnant. They were absolutely thrilled. They wanted to know how they could make sure that both of them were on the birth certificate. They were not married. So in that situation, I had the horrible job of having to say, well, unfortunately, because you're not married, artificial insemination at home, you won't be able to be on the birth certificate, partner B, and only partner A will be the legal parent. A number of months later, I actually had a lovely email from this couple saying that they went to the registrar office, it's all fine, and they put them both on the birth certificate. I don't know how they convinced the registrar to do that or how that happened, but if that were ever challenged later, they are really got a can of worms that they're going to have to deal with, because partner B should not have been the legal parent. I've also had the same situation from the reverse, really, where I had a woman come into the office who was in a same-sex marriage, and they had a child together, and she told me she wanted a declaration of parentage because they had misled the registrar into believing that they were married at the time of conception when in fact they weren't. The date of conception is the key here, not the date of birth. So it's about the conception. They weren't married at the date of conception. They married in between the conception and the birth, but the registrar put them on the birth certificate on the basis of that marriage. And this woman was coming to see me now. She wanted to cut her ex-partner out of her child's life. And her position was very much, well, she shouldn't have been on the birth certificate. She's not a legal mother. Let's just get rid of her. Declaration of parentage. As you can imagine, I talked about psychological parenthood. This child had been brought up by both of their parents, very much viewed them in that way. And perhaps unsurprisingly, I didn't actually get instructed on that case because I suspect she did not like my advice very much. I don't think we can talk about this area of law without looking at a reported case from earlier this year, which really demonstrates the issues that you can come across here with birth certificates. So this is a case of P versus Q and others. Mr. Justice Knowles said, this case is a cautionary tale about the consequences for a child and for a same-sex couple of both deceits as to how the child came to be conceived and the unreliability of informal arrangements for artificial insemination. The fallout from this couple's separation has been devastating for each of them and for their named sperm donor. So in this case, we have a same-sex female couple. P is a biological mother of X and was married to Q at the time of conception. F was a named sperm donor, so someone they knew. P had sex with F in the conception window, but did not tell Q. So P and Q registered the birth together, with Q named as a second parent on the birth certificate. Q had no idea that conception was not necessarily when she thought it was. So P and Q subsequently divorced, and in 2021, there's child arrangement proceedings, and there's no issue raised about the method of conception or legal parenthood at that time. But P and Q later fall out over F's involvement in their lives, And at that stage, P issues an application for a declaration of parentage. So the dispute was X conceived using artificial insemination? And if so, Q is the legal parent, which has always been the understanding. Or was X conceived via natural conception, which would mean that F is actually X's legal parent. So as I said earlier, the presumption of legitimacy doesn't apply to same-sex couples. So there's no presumption that X is Q's legal child. And in this situation, the court, quite frankly, could not be sure when and how X was conceived. And the court ruled that where there's no finding that could be made that the child was conceived by artificial insemination, we needed a positive finding there that X was conceived through artificial insemination. The court has to rely on common law and not the Human Fertilisation and Embryology, the HFEA 2008, to establish legal parentage. So in that situation, the declaration of parentage was made. So X's legal parents essentially changed. P and F, who was the sperm donor, are X's legal parents, and Q, who has always been the legal parent since birth, is no longer. So the judge talks about the impact on same-sex couples.
So just to be clear, Lauren, just to be clear, this is quite scary actually.
It's absolutely terrible.
Because the child and one parent, one of the mothers, were under the impression that she was the parent, and the child thought, well, I've got two parents, and all that was literally turned on its head because of what actually happened, namely the other mother had sexual intercourse during that window.
And the judge talks about the impact on the parents, but it must have been devastating for that child as well. Essentially, life as you know it suddenly shifts. So it's why, number one, how important it is to get this right, but also number two, how important it is to check, because there were already child arrangements proceedings in 2021, and this didn't come out at that stage. So let's move back on to talking about Claire, Tracy, and Freddie. So the first question I would ask is, who gave birth to Freddie? So Claire tells us it's Tracy, so Claire isn't Freddie's birth mother. Was Freddie conceived in a licensed clinic? If the answer is yes, as we said, we checked that all the forms they presented together, they completed the forms together, and if so, they're going to be the legal parents and should both be recorded on the birth certificate as such. If not, and they didn't present together, then Claire's not the legal parent and she shouldn't be on that birth certificate. So what if the answer is no and Freddie was conceived through artificial insemination at home? So one thing that I have noticed dealing with this sort of work is opposite sex couples are perhaps more likely to use a clinic. Generally, they've turned to donor conception as a result of fertility investigations. They're already in that medical arena. The natural next step is to continue the work in the medical arena, use a clinic. When we're dealing with women who want to become single mothers or same-sex couples, sperm donation is the first port of call. Women in this situation are also less likely to have access to treatment on the NHS, and cost can be a really huge factor in deciding what route to go down. And it's for this reason that I personally, in my work, am seeing a lot more people doing the artificial insemination at home and having to come across these sorts of issues. So if Freddie was conceived at home, I've lost my mouse, there it is. Tracy and Claire, we know they're not married or they're in a civil partnership. So Claire's not Freddie's legal parent and she shouldn't be recorded on the birth certificate as the second parent. One thing that they may not have appreciated if they didn't get legal advice at the time as well is that the donor is Freddie's legal father, but he won't have parental responsibility unless he's been named on that birth certificate, which one would presume he isn't if this was intended to be a donor conception arrangement.
Because there's two different things going on there, isn't it, Lauren? It's legal parent and parental responsibility. They're two different things.
They are. They don't always follow each other, and we always need to remind ourselves of that. So what can Claire do if she's not Freddie's legal parent, and how can we help her? I mean, the first thing that would come to mind is adoption. We can't go down the sort of step parent adoption route generally because they're not in a relationship. It's unlikely that would be approved. And we've got the same issue with the step parent parental responsibility agreement or order as well. This is a separated couple. We need to think creatively in these sorts of situations. And I think what I would be thinking about for them is a Section 8 order. So if Claire had a lives with order, it should automatically be granted parental responsibility. And of course, if there's no dispute, you can apply for these orders by consent. So you can get an order in place, not because there's a dispute over where the child's living or spends time with, but just to deal with this parental responsibility issue, because Claire is a psychological parent in this situation. And the thing to bear in mind is, although it's not automatic, the court can also grant parental responsibility alongside a spends time with order for the duration of that order. So we have options, we can be creative here. The thing we have to remember, just like in the last scenario, is if Claire's not a legal parent, she doesn't have PR, she doesn't automatically have the right to apply for these orders. So we're going to have to make an application for permission to make the application. I would imagine it would be granted because she's clearly got a existing sustained parental relationship, essentially, with Freddie.
So this is worth remembering, of course, the Section 8, but Section 12 in terms of the parent responsibility spends time with order is also useful to have in the armoury.
Definitely. And it's one that I think is really easy to forget about because it's not automatic. So when these couples present to you who have had a child through what they consider to be a donor conception arrangement, may or may not be, as far as the law is concerned, they will often, not always, have a donor conception agreement. So what impact does that have? Well, these are not legally binding documents. They're very helpful evidence of everybody's intentions at the outset, so we can refer to them if there's a dispute later, but they aren't legally binding. They cannot change legal parenthood. So even if that arranged agreement, and I often see ones that have been made with US pro formas, even if that agreement says these are the legal parents, the donor is not the legal parent, that does not matter. It doesn't override the HFEA or the common law position on legal parenthood. It may well be they want to behave in that way, but we can't override the law. It can't oust the jurisdiction of the CMS. So if a man who thinks he's been a donor finds out he's the legal father, he needs to be aware, or enters into this agreement with a single woman or an unmarried woman. He needs to be aware that he would be the legal father. Whatever you say in these agreements, there can be a claim under the CMS. It also impacts on intestacy. The most helpful thing about donor conception agreements, and I do draft these, and I tend to do them pretty detailed, is that it makes sure that every party really understands their legal rights. And in the agreement, I make it very clear that we can't change legal parenthood or parental responsibility with this agreement. We can't oust the jurisdiction of the CMS. However, these are the intentions. So everybody understands what their rights are, what their responsibilities are, what the risks are, but also the expectations. Because in a lot of these situations, when we see them later, when there's a dispute, it's not necessarily because someone's reneged on the agreement or changed their minds. It's often because people have had different perceptions of what has been agreed in the first place. A bit like when we do parenting plans in Section 8 work, just having everything in as much detail, put in black and white, in writing, everybody knows what the expectations are. And just as an aside, everybody entering into this sort of situation, agreement or not, should get legal advice and counselling. So I really do try and push all my clients who are entering into a donor conception agreement down that road of counselling, because the implications are huge. There are lots of things that people don't think about. A big one I find that people are reluctant to think about is actually how this child fits into their extended family. Have they told their parents, their siblings, that there's this biological family member out there? How is that going to be dealt with? So the counselling can be really important with that, as well as with assessing their own relationship to the child and with the other people involved in the arrangement.
And I suppose the impact on the identity, the child's own identity and sense of identity of any half siblings, for example.
Absolutely. And what people are going to be told, if we're talking about artificial insemination at home, it is almost certainly going to be a known donor, because the clinic isn't going to give you an unknown sample to take home out of a registered clinic. So you're going to almost certainly know this person. What role are they going to play? Are they going to be a family friend? Are they child going to know that they're the donor? How are you going to deal with that? And this has huge ramifications for the parents and for the child and for the donor. So it's really important that people really do think this through. And it really worries me when people don't want to do the counselling, I've got to be honest. So that's the end of everything we had prepared. Richard and I are here and happy to answer questions if anybody wants to unmute and ask any. If not, we'll wrap up.
And thank you very much for listening.
Absolutely.
Got no questions in the chat.
No?
Thank you. That was very comprehensive. Thank you.
Hopefully we haven't bamboozled everybody. I'm happy to share the slides after. I know that flowchart is particularly helpful, I think.
Really helpful. Thank you very much. This is, as you know, everybody's recorded, so it will be available on the YouTube for East Sussex Resolution. And thank you so much to the two of you. Fantastic.
Thank you all.
Thank you for having us.
Bye.
Bye.